All right, all right, all right. So let's talk about one of the biggest, most important cases that SCOTUS has heard in quite some time. Really, really, really important case. So before we get into it, I want to thank you for joining me. And I kind of want to walk you through what is happening with this case, some of the oral argument today, and what, if anything, we can do, and how do we get here? How did we actually end up where we are now? That's the question. So I'm trying to set this up where I can actually see your comments. Okay? So just bear with me here. Let me find your comments. See your comment. All right, we don't want that. That's a little feedback right there. But I think I got rid of that. All right, so we're going to get into this all-important Section 2 of the Voting Rights Act. The Voting Rights Act. The Voting Rights Act. It was signed into law August 6, 1965. And here we are 60 years later, just a little bit over 60 years later. And they are about to knock the next most important leg out from under it. How did that happen? How did our generation allow them to take what is the signature legislation of the civil rights movement? How did they do that? What happened? Where did we go wrong? I mean, that's the way we should look at this. We are able to vote today because of the Voting Rights Act. The 15th Amendment gave us the right to vote, but white supremacists didn't want us to vote, and they erected all types of barriers. Poll taxes, literacy tests, grandfather clauses, violence, all kinds of schemes to keep us from casting our vote. And that should tell you right there how important voting is. Now, we know there are people all over social media telling you that voting is not important. Well, they're lying to you. They're lying to you, and I believe it's intentional. I believe it's intentional. So we're going to get into it. And I am a civil rights lawyer. I don't play one on TV. This is what I literally do. I know what I'm talking about. This is what I do on a daily basis. I'm not just a content creator. And I have to say that because there are a whole lot of folks online on social media saying a whole lot of things that they don't know what they're talking about because they never went to law school. They never studied civil rights. They never studied constitutional law. They don't know any of this. Yet, unfortunately, quite often, those are the people that a whole lot of our people like listening to. Not the experts. It's like when COVID was around. People listening to, shade tree doctors. instead of going to the medical expert who has spent time in college, in medical school, residency, intern, fellowships. The same with attorneys, college, law school, law degree, bar exam. Got to pass the bar exam to show that you know what you're talking about. Well, I passed that 3-day exam almost 20 years ago. So what you're going to get tonight is the truth and accuracy. So let's get into it. I'm going to go to another screen so we can get into it. Letting a few more people jump on. A few more people. There are 90 people that I can see. That ought to be 900. That ought to be 2,000, 10,000 people listening to how we, this generation, has almost lost the most important civil rights legislation that the civil rights movement gained for us. Dr. Martin Luther King Jr., John Lewis, Reverend C.T. Vivian, Reverend Joseph Lowry, Reverend Hosea Williams, Medgar Evers, Rosa Parks, all these people. Oh my God, they made so many sacrifices to give us the opportunity to pick, to elect the people that we want representing us. And here we are 60 years later in my lifetime. I was born in 62. So this piece of legislation was handed down in 65 over the objection of white supremacists, racists, the Citizens Council, all kinds of whites who did not want us to vote. Yet we were able to gain the right to say who we want representing us. And in my lifetime, we have allowed them to gut this. Now, the first time they gutted was in 2013 with the Shelby County versus Holder case. That's when they got rid of Section 5, which required that notorious states that had a history of voter suppression had to get pre-clearance. In other words, they had to submit to the Department of Justice whatever plan they wanted, they had to change their voting laws. They had to first get the Justice Department to approve it. And that way, that prevented them from putting all kinds of things in the law to prevent us from voting. Well, they got rid of that in 2013. Okay? They got rid of that in 2013. Section 5 no longer requires that those certain states get pre-clearance. That was a huge blow to the Voting Rights Act. Section 2 is what this fight is about now. Was all about, or is all about, it's not gone yet. It is all about racial gerrymandering. When we fight racial gerrymandering, we do so under Section 2. And that's what the fight is about. And think of it this way. Section 5 stops them from preventing us from voting. Section 2 stops them from weakening our vote once we vote. You see, we need protection both ways. We need protection to prevent them, to stop them from getting in the way of us voting. And then once we vote, we need the full power of our vote being felt. Section 2 protects the power of our vote. Section 5 protected the opportunity for us to vote. It protected our right to cast a vote. Section 5. Section 2 protects the power of our vote. And again, that's what this fight is all about. Today, Section 2. Now, Section 5, remember, we are still trying to get that pre-clearance requirement restored through Congress. All right? The John Lewis voter registration, the John Lewis voter rights law. I don't know the exact name of it, but that's close. And we got it through the House. The House passed it, but we couldn't get it through the Senate. And that's been the holdup. Now, with this Section 2, we're in a jam now because there are 6 conservatives on the court. 6 out of 9. 6. I listened to the oral argument today, and I'm going to play some of it here just for you in just a moment. But they had been resisting efforts from Clarence Thomas, who wanted to see Section 2 gone. He voted to get rid of Section 5, and then he sort of made it his personal business to get rid of Section 2. And the case that they heard today had already been argued. But Clarence Thomas pushed the court to allow a re-argument so that he could once again go after Section 2. It is the reason why I've made so many videos and where I've said use the hashtag Save Section 2, because I knew this case was coming. I know how important this case is. And you recall a few weeks ago, Texas state Democrats were fighting to prevent the state of Texas from racial gerrymandering about 5 seats. I mean, they went to the extent of leaving the state and staying away as long as they could. Well, it is that type of case that is decided by Section 2. And if it's gone, if Section 2 is gone, and you're going to hear in a moment, Janae Nelson, who is over the NAACP Legal Defense Fund, and she did a bang-up job today in front of SCOTUS. She did a tremendous job today. I mean, it was flawless, the job she did arguing for Section 2. So anybody who tells you that the NAACP or the NAACP Legal Defense Fund is no longer valuable, is not doing any work out here for the African American community, they're just flat out lying to you. And there's a whole lot of lying going on online to black people. Got a lot of black people confused. Janae Nelson did a bang-up job today. You're going to hear in just a moment. So the NAACP has been fighting Project 2025. It has been fighting those conservatives who are trying to get rid of the Voting Rights Act and the Civil Rights Act and the Fair Housing Act. They're trying to get rid of it all. And thank God the NAACP is still our flagship organization to fight against this. So go over and support them. How did we get here? It's simple. Let me show you. It's really simple. Right there. Those four men put those conservatives on the court who got rid of Section 5 and are going to get rid of Section 2. Now, Trump didn't put anybody on the court when Section 5 was gutted in 2013. Trump had not been elected yet. Okay? But he, since then, has put three folks on the court. And so you may say, well, again, how do we get here? Because we got each of those presidents that I just showed you because we voted between 50 and 60%. When we vote between 50 and 60%, bad things happen because that is exactly what they want. And that is exactly when they take the opportunity to start cutting away at things that benefit us. They start going after our progress. Keep those numbers in mind. When we vote between 50 and 60%, that means a whole lot of African American people don't vote. And when we don't vote, we get that. When our voting percentage is between 50 and 60%, we get GOP presidents. And I want to be exact about that. We get Republican presidents. We get GOP presidents. And this is what they do. They put folks on the court who start taking away all that we have gained. So you have to ask yourself, why would any African American person vote for a GOP president? Because you know what they're going to do as soon as they get in office. They're going to take their hatchet and start cutting away benefits for you and me. When we vote 50 to 60%, we get these folks. But when we vote above 70%, 70, 80%, we get folks who will not take away benefits from us. Like Barack Obama, like Joe Biden. Well, why didn't Kamala win, who would definitely not be working against the Voting Rights Act? Because we voted between 50 and 60%. I want you to know those numbers. When African Americans, you know, a lot of us said, a lot of you all said that in 2014, November 2014, you all love to say 92% of black women voted and 80-something% of black men voted. And I have told you so many times that 92% of 50% of us voting is not good enough. So that 50 or 40% something percent who went and voted, 92% of them voted for Kamala. I get it. But almost 50% of the black community stayed home. And I'm talking about eligible black voters. That was the reason why Dr. King, Dr. Lewis, Representative Lewis, Fannie Lou Hamer, that was the reason why those folks worked so hard, gave their lives. Medgar Evers was shot in the back, taken from his family because he was out registering people to vote, and he got home late one night and they murdered him because they didn't want him doing that work to get us to vote, to enable us to vote. And despite all of that, 50 to 60% of us routinely are the numbers that voted. When that happened, it's really simple. When 50 to 60% of us vote, those people get in office. So you should give anybody who tells you don't vote, you should give them the side eye. I mean, you should be like, what? So you don't want me to vote? You're telling me not to vote so that the GOP candidate can win and start cutting back the Voting Rights Act and the Civil Rights Act and the Fair Housing? How does that make sense? Oh, well, what we're doing is we're getting the attention of the Democrats who hasn't done anything for us. Haven't done anything for us? Really? We couldn't vote if it wasn't for the Democrats. We wouldn't have civil rights if it wasn't for the Democrats. We wouldn't have the fair. So much we wouldn't have. We wouldn't have things if it wasn't for the Democrats. You should tell them, you talk like we're back in slavery when the Democrats were definitely the party that were trying to keep us in slavery, but that's not that same Democratic Party anymore. So what do you mean? When we vote, 50 and 60% folks, we get them. And then they start gutting stuff. They put folks on the court to gut stuff. I did a video a few weeks ago on Instagram where I said when folks voted for Trump, they didn't just vote for Trump. They voted for Mitch McConnell. They voted for Ted Cruz. They voted for Project 2025. They voted for the elimination of Section 2. They voted for all that. All right. Do you notice frustration in my voice? Yeah, I've been frustrated since November 2024. I have. I beg people not to let this happen. I did. And others. And so now we're in this situation. Someone said, well, once the Democrats get back in office, we can just reinstate Section 2, Section 5. Ideally, yes. Ideally, Congress can restore Section 5. Congress can restore Section 2. But what is that going to require? More than 50 to 60% of us voting. because otherwise the GOP is going to do what they always do, block it. They're going to block it. All right, folks. I see some of your comments here. Yes, someone said 92% black women saw the snake. We stood tall. Yes, as I explained, that is awesome. That is awesome. And a majority of black men as well. That is awesome. That is awesome, sister. Thank you for saying that. But we got to get the other part in our thinking as well, which is we need 92% of about 70% of us voting. So look at it this way. 100% of 50, okay, 100% of 50%. In other words, think about an apple. Cut the apple in half and then set one half to the side. And let's say you eat 92% of that half of that apple. Well, you only ate half the apple. You still got another half over here that is spoiling. Well, that's what I'm trying to say. When we have 30-something million people who are eligible to vote as black people, and only 50% of them go vote, we just disenfranchise ourselves. But when 70, 80% of those eligible voters, black voters, go vote, we can stop anything they do. And we can get anybody elected that we want. They know that. That's why they try to keep a certain percentage of us from voting. Because they know they just need a percentage. They just need a percentage of black people staying home or voting GOP. And there they got us. So it doesn't matter that 92%, that's a great thing. Don't misunderstand me. Keep that up. But what I'm trying to stress is, in addition to that, take 4 or 5 sisters with you. Take 4 or 5 brothers with you. You dig what I'm saying? Because then we're getting more of that apple. Half of it is not sitting over there spoiling. We're bringing more of it with us. Because again, when we vote, they can't stop us. That's why they gutted Section 5, because they can't stop us. When we vote, we get who we want. I remember Reverend Jesse Jackson saying this all the time. When I was in college and so forth, I remember Reverend Jesse Jackson always talking about voting data. How many voted? How many didn't vote? And it's so true. It's so true. A lot of times these elections really hinge on whether 10 or 15 or 20,000 of us go vote in a particular area. And that's why they do everything they can to keep us from voting. They don't want. They're on the record saying, I could play you videos of them saying, we don't want everybody voting. And so when they got rid of Section 5, they came up with all these voter suppression laws. And now they're trying to dilute. And when I say dilute our vote, what I'm saying is, let's say you got a cup of coffee that's black, no cream, no sugar, black. And then let's say you start putting a whole lot of cream in it. Cream, 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 cream. Before long, you don't have a cup of coffee. Not only cream, but sugar. You have essentially diluted that coffee. That's what they try to do with our votes in violation of Section 2. All right. Let's listen to some video here. I don't have the actual video because they didn't release the video. What I have is audio. But I want to hear you. I want you to hear how well, just awesome, civil rights attorney Janae Nelson did today. Really, I got to give her just another shout out. She did awesome. She did awesome. Now, whether she convinced people, I don't know. And I'll tell you somebody else who did awesome today. Justice Jackson. She's not just a symbol on the court. That woman is fighting for black people. She's fighting. She's up there like Thurgood Marshall. You've heard of Thurgood Marshall being up there fighting for civil rights? That's who she is. That's who she is. She is fighting. She doesn't care what they think. She is fighting for us. And that's why I wanted for the last 10 years for a black woman to be on the court, a sister. And she's up there and she's fighting. All right, let's listen to some video.
We will hear argument first this morning in Case 24-109, Louisiana versus Calais, and the consolidated case. Ms. Nelson.
Thank you, Mr. Chief Justice, and may it please the court. A mere 2 years ago, in Allen versus Milligan, a case nearly identical to Robinson, this court noted that under certain circumstances, it has authorized race-based districting to...
We in the past have had some issues with echoes. Please let me know whether or not you're hearing any echo. Please let me know.
To remedy state districting maps that violate Section 2. Louisiana affirmed findings that, six appellate judges affirmed findings that Louisiana, in the face of extreme racially polarized voting, packed and cracked black voters, and it rejected 7 non-dilutive maps in favor of one that would give its 58% declining white electorate entrenched control over 83% of the congressional districts. Louisiana's creation of a district to remedy that discrimination and to ensure that black Louisianans have an equal opportunity to participate in the process is constitutional. Precedent from Brooks to Milligan, from Ex parte Virginia to SFFA confirm that. And 3 facts guard against indefinite use of race. First, not all Section 2 remedies center race. Second, when racialized politics and residential segregation wane, so will the ability to satisfy jingles. Third, almost every redistricting map is replaced decennially. My opponent's late-breaking and recordless facial and as-applied challenges seek a staggering reversal of precedent that would throw maps across the country into chaos. If SB 8 is unsatisfactory, the proper recourse is to remand and adopt one of the many alternative maps that address the Section 2 violation and satisfy the Constitution. As this court noted in Milligan, Congress is undoubtedly aware of Section 2 precedent and can change it if it likes.
Now, let me explain to you some of what is being said here, okay? So this involved actually 3 different cases. 3 different cases. A case out of Alabama, and I covered it in a video, I think it was last year, and a case out of Louisiana. And basically what it is, you look at the population of a state, and if the African American population is, let's say, like in Alabama, is like 30% of the population, of the total population of the state of Alabama. So the NAACP represented some plaintiffs who said we should have more than one district. Okay? We should have more than one district. We should have 2 districts. I think there were a total of 8 districts. And when you represent 30% of the population, then you should have more than one district, they argued. And that they argued that based on Section 2. All right? And the Alabama, they went to court. The judges forced, even SCOTUS, forced Alabama to create a second black majority voting district in Alabama. That's the Milligan case that you hear them talking about. And because they did that in Milligan set a precedent that Janae Nelson is now using and arguing that the court should follow in the Louisiana case, which is almost exactly the same set of facts. The population in Louisiana of African American people is enough to have at least 2 voting districts. And so the state of Louisiana created that second black majority voting district. And that's when plaintiffs sued and said that is racial discrimination. And why? Because they said, here's what they said. And this is what this thing is all about. The plaintiffs who did not want blacks having a second black majority district said that the courts created that second district based on race. And that violated the Equal Protection Clause, all right, of the Fifth Amendment. They said that violated the Equal Protection Clause of the Fifth and 14th Amendment, actually, all right, because race was taken into consideration. So Janae opens her mouth, and the first thing she says is Section 2 cases are not necessarily centered in race. Not necessarily. And so she's trying to say that what you should do, SCOTUS, is follow your previous ruling in Milligan and uphold this second black majority district. All right, so that is the context. Now, with that in mind, I hope I explained it. If you don't understand it, ask, please, in the comments, and I will try to explain it better.
But unless and until it does, statutory stare decisis counsels staying the course.
Stare decisis is a Latin term that means, as she said, stick with what you have already decided. In other words, stay with the precedent. Don't, and I didn't say president. Okay, let's be clear about that. Not stay with the president, with the precedent. In other words, stick with what you already ruled in other cases. And in this case, that would be the Milligan case out of Alabama. I think it was back in 2023. So she's saying stare decisis would bind you all to treat this Louisiana case the same way you treated Milligan. And guess what? Guess what? When this case, when the Milligan case, when the Alabama case reached SCOTUS, they upheld that second voting district. It surprised everybody. They upheld it. And the only one who was unhappy about that was Clarence Thomas. And that's why he said in his dissenting opinion with the Louisiana case, he said, I've been trying to get rid of Section 2 for 30 years. He literally said this in his dissent. So we need to bring this case back up and re-argue this again. So this is actually the second time this has been re-argued. And he's saying we should not stick with Milligan. We should not stick with precedents. We should get rid of Section 2 because it violates the Equal Protection Clause.
I welcome your questions.
Counsel, what was the finding or the holding in Robinson, and what role does it play in the SB 8 map creation?
The finding in Robinson was that there was a likelihood of succeeding in a Section 2 claim proving that the state of Louisiana violated Section 2 by packing and cracking black voters. So there was a Section 2 liability finding under a preliminary injunction, and there was an ordering of a new map to be drawn.
What is the status of that case now?
Robinson is concluded, and there's now...
So notice the first person who asked her questions was Clarence Thomas. And you notice also she used two terms, packing and cracking. That's what happens in racial gerrymandering case. It's what has happened here in the state of Texas. Let me briefly explain it. So here in northern Texas, in the Dallas-Fort Worth area, there are two representatives, two African-American representatives whose districts have been impacted by this new map that Texas created. Mark Vesey, Representative Mark Vesey over in the Fort Worth area, and Representative Jasmine Crockett. And so what they did was they cracked, just like cracking an egg. They cracked those districts, okay, broke them apart, and then they packed them together. They cracked it and took part of Mark Vesey's district and put it there with Representative Jasmine Crockett. And then so they also essentially cracked Representative Crockett's district and packed it with Mark Vesey, which means then they have put a whole lot of black people into one district so that they are not controlling or the majority in two districts. That's cracking and packing. That is racial gerrymandering. That is in violation of Section 2.
Now, as we know, the challenge in Calais that suggests that their map that was created out of Robinson, SB 8, is a racial gerrymander, and that's why we're here today.
So SB 8 was the remedy for the Robinson case. I thought that was a preliminary injunction.
Yes, there was a preliminary injunction indicating that we were likely to succeed if we continued to pursue a claim. This is after a 5-day hearing with 21 witnesses and a robust record. So the court found, based on that evidence, that we were likely to succeed on a liability and ultimately instructed the state of Louisiana to draw a correct and constitutional map.
But there was never a full merits determination.
That's correct.
SB 8 was entirely separate, though, from that litigation.
SB 8 came after the litigation. It was in response to the court's order to create an opportunity district and a second map that would cure the Section 2 violation.
But did the court order this particular map?
No, the court gave the state of Louisiana an opportunity, as this court has suggested it do. It gave it broad discretion, gave it wide latitude to create a map that it felt was satisfactory, and ultimately that is the map that was in effect and elected a congressional delegation in 2022.
Counsel, you began with Allen against Milligan. That case, of course, took the existing precedent as a given and considered Alabama's application of its approach to the evidence and all that under that precedent. Is that your understanding as well?
That's correct. In fact, the case was stayed because this court held that case in abeyance until it decided Milligan, because it understood Milligan to be important to understanding the case in Robinson.
But it was a case in which we were considering Alabama's particular challenge based on its what turned out to be an improper evidentiary showing.
I'm sorry.
In other words, we were looking at Alabama's suggestion that how to apply its body of evidence or which evidentiary considerations we should take into account under the existing precedent.
That's correct.
Thank you.
But I would ask you to just expound a little bit on why you think then that Allen versus Milligan is relevant, or the fact that we held or what we held in that case is relevant to what we're doing here today.
Allen versus Milligan is in.
Now, what Justice Jackson here is doing is she is giving Janae Nelson the opportunity to further explain what she was trying to say. In other words, so that she could offer an answer to Justice Thomas as well as Chief Justice Roberts' questions. You'll see that. They often do that when they are trying to help one of the litigants explain something better. When it's their turn to ask a question, you will see them asking that person a softball question so that that person can get that information out to answer the other justices' questions. So that's what Justice Jackson here is now doing.
Nearly identical case. There was a similar challenge where we won on a preliminary injunction that there was a Section 2 violation because the state of Alabama in that case cracked and packed the black community, cracked the black belt. And ultimately, this court found that that was a clear violation of Section 2. Similarly, what we have in Louisiana is a circumstance where Louisiana was constructing a map and had a single district that could elect a preferred black candidate and had an opportunity to draw a second district based on the size and geography of its black population, and chose not to do so in the face of 7 illustrative maps that made clear that they were not dilutive.
And what we in part were considering in the context of Milligan was whether or not to change the Section 2 criteria, the Jingles criteria. Is that your understanding?
That's right. The state of Alabama
and we chose not to.
The court was very clear about that.
And so the parties, I took your initial starting with Milligan to be a suggestion that we not revisit the determination that we made just 2 years ago that the Jingles test not be revised.
That is absolutely correct. And in fact, appellees on page 11 of their supplemental brief state that they understand that this court answered that question clearly, that the results is a constitutional test, that race can be used to remedy violations, and it therefore isn't making that particular argument. In fact, even the SG acknowledged that race can be used in a remedial form when necessary. So those questions have been asked and answered by this court in Allen versus Milligan, and some parties here recognize that those are closed questions.
Can I ask you a question about what Milligan means? In Milligan, the court said that the first Jingles precondition is that, quote, the minority group must be sufficiently large to constitute a majority in a reasonably configured district.
The Jingles test, you keep hearing them talk about Jingles. The Jingles test is a 3-part test that a plaintiff must satisfy in order to show that a state has engaged in racial gerrymandering. All right, it's called the Jingles test based on another case, and again, before the plaintiff can convince the court that there's racial gerrymandering going on here, they got to meet those 3 Gingle criteria. Okay, so that's what that Jingles is, and it's not enough time for me to go into all 3 of those. But Justice Alito is talking about one now, which is whether or not the minority group is compact, the district. He's asking a question about whether or not the district is compact, not the district, but whether or not the folks living in the district are compact, meaning if some of these voting districts can look like a snake, and the Jingles test require that they be compact, not like a snake, but more like an animal, put together like a ball or something, and not long and elongated like a snake. So that's what he's asking about.
And it went on to say that a district will be considered reasonably configured if it comports with traditional districting criteria. Would you agree that incumbent protection is one of those?
Incumbent protection has been considered a traditional districting criteria. However, we know that protecting an incumbent, like core retention, can continue to perpetuate discrimination, and it does not trump the anti-discrimination
All right,
law.
if incumbent protection is a permissible districting criteria, then under Rucho, isn't seeking partisan advantage also an objective that a legislature may legitimately seek?
Now, what I want you to pay attention to here is they're asking her about different cases. All right, Ruo, the Milligan case, the Louisiana case. They're going to ask her about the Students for Fair Admissions case. And to do this appellate advocacy, which is what she's doing here. And by the way, and let me just throw this out, in law school, I competed in an appellate advocacy program, and out of about 200 students, I won third place. Should have got first, but I kind of came on strong too late. So this is not easy work that she's doing here. I mean, she would have had to prepare for months and months, knowing everything about each of these cases and then being able to articulate, answer their questions. And that's what, on TV, what you see quite often is when you see one of these lawyer movies, you will see the attorney standing up giving a speech in front of the jury or in front of the judges, and it moves everybody to tears, and folks, that is not the way that happens. The real way that happens, you're seeing it. You stand up there and you may get to do your introduction in the first 2 minutes, and here they come with all the questions. So what you got to do is be prepared to answer their questions. You're not going to have the opportunity to give a speech, all right, like you see on TV. So she has very well prepared herself so that she can answer their questions and continue to advocate for her clients. And she's doing a tremendous job. All right, let's go back.
Not if it comes at the cost of the equal protection principle and the 15th Amendment's prohibition on race discrimination in voting. It is not.
Well, if the objective is simply to maximize the number of representatives of a particular party, that's seeking a partisan advantage. It is not seeking a racial advantage. Isn't that right?
Well, if race is used as a means to seek the partisan advantage, then that is unconstitutional.
Oh, sure,
There's no
if race is used as a proxy for partisan affiliation. Let me ask you a related question.
So right there, they're talking about the difference between political gerrymandering or partisan gerrymandering and racial gerrymandering. The United States Supreme Court has held that partisan or political gerrymandering is constitutional. And that's what the state of Texas is here arguing, that the new map that they just drew is political gerrymandering, which basically benefits, yes, the Republican Party, which SCOTUS has said that's okay, but that is not racial gerrymandering. And as she just said, if you're using race to get to the partisan or political advantage, then it still is racial gerrymandering. And that's exactly what we have here in the state of Texas. The fact that they have gotten rid of or weakened or diluted Black and Latino voting districts, what does that tell you? That tells you this is racial gerrymandering. But here's the thing. If they get rid of Section 2, then the Texas racial gerrymandering, it'll be hard to overturn it. Because what we use to fight racial gerrymandering is what they're going to decide on, whether or not it's going to even survive.
About block voting, which is the second, figures in the second and third Gingell's precondition. If registered Democrats overwhelmingly vote for Democratic candidates, regardless of the candidate's race, is that block voting?
If you're looking at it simply from a party perspective, no, we don't judge block voting based on party. We judge it based on race. Racially polarized voting is measuring racial performance and voting behavior.
And likewise, if registered Republicans overwhelmingly vote for Republican candidates, that's not block voting.
That's not how we measure voting. We measure voting based on race for purposes of Section 2 because the Constitution forbids race discrimination in voting, not party discrimination.
All right, so if it happens to be that people of one race or another race overwhelmingly prefer one of the political parties, does that transform the situation into racial voting, or is it still just partisan voting?
No, you look at how different races of voters vote and whether they vote in a way that is polarized. And the Gingell's test requires us to look not only at that, but a number of other features as part of the totality of the circumstances test that suggest that race is playing a role to contaminate the electoral process and submerge minority votes in a way that violates the Constitution. So party cannot explain away a racially polarized circumstance unless we look at the totality of the circumstances. And I will say, in Robinson, for example, the court entertained testimony along those lines, as it did in Milligan, and found that it wasn't credible, that the extreme racially polarized voting that we have in the state of Louisiana cannot be explained away by party. We're talking about racially polarized voting that is above 84%, which is more than what this court found in Thornburg versus Gingell's in 1986, and the numbers were 7%.
That could be easily analyzed by statistics to see whether whether white Democrats vote for black Democratic candidates at a lower rate than they do for white Democratic candidates, whether white Republicans vote for black Republican candidates at a lower rate than they do for white candidates. It's easy to.
Now, we've been here now for going on an hour. I want to jump to, I got more here, but I want to jump to, there was a question asked of Ms. Nelson that wanted to know what would be the impact of getting rid of Section 2. And after we hear that, I want to play a clip of Justice Jackson's questioning of the Solicitor General for the state of Louisiana. All right, so let me just jump ahead.
Would you give us a couple of lines on why those, assuming, as the chief did, that Mulligan and all of our cases and precedents support you?
Sure.
The others are now saying, your adversaries are saying, even if it does, we should still declare this unconstitutional. I don't know that you've addressed that.
Happy to. So SFFA is an entirely different case from the one before the court at the moment. SFFA made clear that it is still constitutional to use race to remedy specified discrimination, which is what we have in the state of Louisiana, what we showed before the Robinson court. So SFFA is, in fact, working more in our favor, we believe, than supporting our opponents. And there are many distinctions between this case and the SFFA case. For example, Section 2 is a decidedly remedial statute. SFFA involved the diversity rationale involving a admissions process with a university, not a statute that is derived from Congress's enforcement powers under the Reconstruction Amendments that deals with remedying discrimination. That is a very clear distinction. This court has been clear in Shaw, in SFFA, in Croson, in Fullalove, that you can use race in a limited way to remedy racial discrimination. The other factor that makes SFFA reconcilable with Milligan.
Now, it's important that you understand what's going on right here. So FFA is the case that Students for a Fair admissions against Harvard in Chapel Hill, the University of North Carolina at Chapel Hill, where the court ruled that where it basically got rid of affirmative action. You can't use race as a dominant factor in college admissions because it violates the Equal Protection Clause. And notice this. Our opponents now use that case to say that you can't use race in anything, not just college admissions, but even when correcting a wrong done to us, you still can't use race because of SFFA, the Students for Fair Admissions. You see how they put together a web. They put this stuff together to basically undermine our progress. And why does that happen again? Because of who ends up on the Supreme Court. How does a person end up on the Supreme Court? Because a president nominates that person. And if it is a GOP president, it's going to be one of these kind of justices and judges, because Trump and all the rest of them put a bunch of these kind of judges, not just on SCOTUS, but throughout the federal judiciary. And I'm telling you that when we walk into these courtrooms and we see someone who've been appointed by this president or that president, because we would have done our research, it's like, wow, we're probably not going to get any breaks here. And so that's, to be sure, how she feels. There are 6 conservatives on this court, and they don't like her argument. Okay? So she's and she's doing a great job having to try to convince them. And she's getting help from the 3 other judges, Sotomayor, Kagan, and Justice Jackson.
And which is controlling here is that we know both decisions were issued within 3 weeks of one another. It is illogical to think that this court issued the SFFA decision and Milligan in the same term, in the same month even, and somehow those cases work at cross purposes with one another. So in our view, it is very clear that the case law before this court supports the use of race as needed once there has been a showing of specified discrimination. And the Section 2 test gives the court an inference of intentional discrimination to draw upon. Congress was very intentional in crafting the results test to balance the concerns of getting at all discrimination in our electoral processes, but also being mindful of a potential allegation of racism against states and other state actors. And so Section 2 requires neither a confession nor an accusation of racism. It looks strictly at results, which this court has upheld on numerous occasions, including most recently in Milligan, but before that in Lopez, in Bernie, in City of Rome, written by Justice Marshall for this court, made very clear that results is constitutional and that the use of race is permissible in remedying discrimination.
Justice Kagan?
Ms. Nelson,
Excellent.
Were Section 2 to cease to operate in the way that you just described?
I want you to pay close attention to this question. This is very important. Justice Kagan asked, if Section 2 doesn't operate the way that we're trying to get it to operate, and that's us African-American people, she's asking Ms. Nelson, what would be the results?
Section 2 to cease to operate in the way that you just described to prevent vote dilution in districting. What could happen? What would the results on the ground be?
I think the results would be pretty catastrophic. If we take Louisiana as one example, So Louisiana alone is an example of how important it is to have Section 2 continue to be enforced to create these opportunities. We also know that after majority-minority districts have been created, they often no longer need the same population to continue to provide an equally open electoral process for minority voters. So it is an intervention that has been crucial to diversifying leadership and providing an ability of minority voters to have an equal opportunity to participate in the process, but it also isn't a permanent remedy. It corrects itself over time, and it's only triggered when those extreme conditions exist.
So she just said there so eloquently that let me give you a simplified example. Let's say there are 10 people on a board with voting power. And let's say that of those 10 people, 5 of them are from one family, and the other 5 from another family. And let's say that there's a black family and a white family. And let's say that only one of the black family members is able to vote, let's say. Well, you just diluted, you just weakened those other 4 family members. If a 10-member board has 5 of one and 5 of another, then all of those 5 are to get the opportunity to vote, not just one of them. Well, that's what happened in Louisiana. My numbers are not exact to Louisiana, but blacks there are enough black folks in Louisiana to have more than one black majority district. All right. And the problem is, though, Clarence Thomas is telling his colleagues that, well, even if they deserve another voting district, if race is what is being considered to create that new voting district, then that violates the Equal Protection Clause. So we need to do something with Section 2 because it is in conflict with the Equal Protection Clause. Now keep in mind, both were added to the law to benefit us. And here we have Justice Thomas using one against another against black people.
So where in Section 2 does it mandate another minority district? I mean, my understanding, as I explored with Ms. Nelson, is that Section 2 is the mechanism by which we determine that equal electoral opportunity is not being provided for a certain minority group. And we've interpreted in jingles, we've given some flesh to how one goes about identifying that set of circumstances. But I thought that's the end of it in terms of the court's announcement under Section 2, and the court then turns to the state and says, how do you want to remedy this? We've got a problem. And sometimes the state might draw a second minority district, sometimes it might not. And yet your answer to Justice Barrett was, well, everybody just knows that that's the automatic remedy. So can you help me figure out that disconnect?
Well, Justice Jackson, I think there's a reason why this court's voting precedents going all the way back to Shaw 1 are so tied up with race. It's because the remedy, as parties and the courts have understood Section 2 to operate, is almost always going to be race-based.
They're so tied up with race because that's the initial problem, right? That's the beginning. The beginning is the claim that a person makes under Section 2 that because of their race, they are not being afforded equal electoral opportunity. It is a separate question as to how we go about remedying that and the extent to which we need to use race as a remedy. That's the question we're here on today, but the Section 2 issue is just what circumstances do we look at to determine whether this problem of unequal electoral opportunity on the basis of race is occurring.
Right, and a couple of
That's why I wanted a black woman on the court. because you see how she tore into him, right? You see how what? I'm sure she didn't, but it wouldn't surprise me. She started popping her neck. So look, dude, you're dealing with an extremely intelligent, very well educated African American woman who is centered in the African American experience. And so you're not going to be able to school her or talk over her about an issue she has lived with all her life, the issue of race. A little bit more of this.
Responses to that, Justice Jackson.
Wait, so can I just ask, why is that not a compelling state interest to identify areas in which that problem is occurring?
Your Honor, of course, as this court recognized in SFFA, states can remedy intentional
No, I'm not talking about the remedy. I'm talking
they
about
can identify. Of course.
All right. So if I'm right that Section 2 is about identifying the problem and then requiring some remedy, I don't understand why your answer to Justice Kagan's question about is this a compelling state interest is no. The answer is obviously yes, that you have an interest in remedying the effects of racial discrimination that we identify using this tool. Whether you go too far in your remedy is another issue, right?
Your Honor, I think step zero in all of these cases, it was certainly step zero in the Robinson litigation, is the plaintiffs came in and said, we want another majority black district.
I thought they came in and said, we are not receiving equal electoral opportunity because our votes are being diluted.
Which is the same way of saying we deserve a second
No,
majority
it's
black
not,
district.
because that, again, just trust me on this, the second electoral or second district is a remedy that one could offer for a problem that we've identified. And the whole Robinson litigation was about identifying the problem. Is this really happening? In many, many Section 2 cases, the court says, you're wrong, you're fine. There is not an electoral opportunity being denied to you, go away. In this case, the court said, I see, I'm looking at the factors, I appreciate what you're saying. You've proven that we have this problem. And so the next question is, how do we go about remedying it?
Right, and the problem, Justice
That's why I wanted a sister on the court. She said, trust me on this. She said, I know what I'm talking about. I've been doing this. And he's a young guy. And I think is Hispanic or something. But, she said, trust me on this. I've been doing this before you were born. He's a young dude. And so she is sort of reading him here a little bit. And I'm here for all of it.
Justice Jackson, that the Middle District identified was not intentional discrimination. And in fact, I think
why do you need intentional discrimination to remedy a problem like the one that I've identified?
Because if you're going to use race the way that the Robinson appellants want the court to use race in drawing a second majority minority district, you've got to have a compelling interest.
Thank you.
And thank you, Mr. Chief Justice.
Now, okay, so let me just tell you what he just said. So we're talking about strict scrutiny. If you're going to use race, if a state uses race pursuant to the 14th Amendment, if the state is going to use race, the state has to meet a two-part test. Again, it's called strict scrutiny. And that is, number one, the state has to show that there's a compelling state interest to use race and that their remedy has been narrowly tailored. Okay? And so she said, right. Okay, you got that right. You got that right. But before he could finish answering, I think Chief Justice Roberts stepped in.
Thank you, counsel.
He was saved by Chief Justice Roberts. Oh boy, this was good. This was really good. I love this stuff. I love it. I don't like what's happening right now because we're losing rights. We are losing precious rights. Okay? We definitely are. It is undeniable. And again, what did I tell you? When we vote 50 to 60%, we get this. When we vote 50 to 60%, and I don't care if 100% of black women and black men vote, but only 50% showed up to vote, we get this. That's why I advocate something called impact voting. Impact voting. And that's where we show up. 80 to 90% of us voting, at least 70 in the mid 70s, and then we're all voting for the person, the party that has a history of looking out for us. And when you talk about that history of looking out for us, okay, in terms of civil rights, in terms of fighting police brutality, in terms of prison reform, and so much more. You know who. You know who has done that. It's been progressives. Progressives. And the party that has the progressives pushing for justice, racial and justice and civil rights, it's the Democratic Party. That's just facts. Facts. The other parties start cutting away at what we have gained and putting roadblocks and barriers, but progressives. And there used to be a time that progressives were a part of the Republican Party way back then. They were called the Radical Republicans. They're the ones who fought to end slavery, who got the 13th, 14th, 15th Amendment passed, the first Civil Rights Act. Those progressives back then. But a lot has changed. A lot has changed. All right, so that's going to do it. There is a very good chance that Section 2 will be severely altered, if not invalidated. A very good chance. We will know once they, deliberate and write the opinion and release it. I presume it will be, I don't know if they'll do that before the end of the year, maybe right after the first of 2026. I don't know. There is certainly an interest in them doing it quicker and faster because Trump is trying to get these states to redistrict a whole lot of their districts so that, he can increase his representation or the folks who are going to follow him in the House, which is a reason why not only should we be voting to prevent that, but we should also keep our eye on the Senate, right? On the Senate. So the point is, we got to do better than 50 to 60%. We must. Bad things happen when we only vote 50 to 60%. Bad things happen for us when it's 50 to 60%. Don't let anybody tell you not to vote. All right, so that's going to do it. Thank you so very much. Thank you so very much for tuning in. And that's going to do it. Let me see here. I'm looking at some of your comments. Somebody did say something that I saw out at the corner of my eye I wanted to address, but I don't see it here now. Renee Fox Media said, and I completely agree with this, she said, and that is why the affirmative action case of Howard University in 2023 was so important. That's right, because that wasn't just limited to college admission. The principles behind that is is, they're going to use that across the board. They're going to use that same rationale. You can't use race. No race, no race, no race, no race. All right. Okay. And you all go over to the NAACP and join and support them. This woman right here, Janae Nelson, and all the other ones, especially in the NAACP Legal Defense Fund, this was the group that won the Brown versus Board of Education case with Thurgood Marshall. They've been doing this a minute, fighting for us. And I have seen other content creators say things like we should not support the NAACP. Black content creators, let me be specific. We should not support the NAACP. We should not support the NAACP Legal Defense Fund. What sense does that make when they're literally in the courthouse fighting for us? Okay, I think that's going to do it. You all, have a really good one. Have a really good one. All right? Enjoy the rest of your evening and the rest of your week. I am out.